major Second Amendment case is before the Supreme Court today. Stricter gun laws took another step to become reality, passing the Senate just a few days ago. The bill would prevent the sale of certain firearms. Ruling class just can't seem to avoid trying to trample all over and infringe all of our firearm rights. You can take two clips, you can put them side by side, and then you've just doubled the magazines by having them attached to one another. This is not some gun rights attorney saying it. This is the U.S. government admitting it. They're saying these laws don't survive. Bruen. We could be looking at the perfect storm of Second Amendment cases, all landing in front of the Supreme Court at the same time. The Supreme Court is about to face something it has been dodging for years, and this time there may be no way out. Two landmark gun rights cases are converging on a single conference date, February 20th, and they are not coming alone. Multiple additional challenges to rifle bans and magazine bans across the country are stacking up for that exact same conference. This is not a coincidence. This is a collision course, and what happens next could permanently reshape the Second Amendment landscape in America. Let me explain why this moment is unlike anything we have seen in recent memory, and why the outcome of this single conference could determine whether millions of lawfully owned firearms remain legal or become contraband overnight. For years, the Supreme Court has sidestepped the most fundamental question at the heart of modern gun rights litigation. It is a deceptively simple question with enormous consequences. Does the Second Amendment protect commonly owned semi-automatic rifles like the AR-15 and standard capacity magazines? That is the question lower courts have been wrestling with, contradicting each other and creating confusion for nearly a decade. And the Supreme Court has watched it happen, declining case after case while the chaos deepened with every term. But now something has shifted. The conditions that several justices hinted they were waiting for appear to have finally materialized. To understand why this is significant, we need to look at the two anchor cases driving this moment forward. The first is a case out of Cook County challenging the local ban on so-called assault weapons. This ban sweeps up AR-15 style rifles and dozens of other commonly owned firearms under a broad prohibition. The plaintiffs argue these rifles are in common use by law-abiding citizens for lawful purposes. Under the Supreme Court's prior rulings, arms that are in common use are constitutionally protected. Therefore, a blanket ban on an entire class of commonly owned firearms violates the Second Amendment. The request is simple. The plaintiffs want the Supreme Court to definitively state that states, counties, and cities cannot outlaw firearms that millions of Americans legally own and use every day. The second major case involves California's ban on magazines that hold more than a certain number of rounds. This case has an unusual history. The Supreme Court previously took it up, then vacated it, and sent it back down after the Bruen decision reshaped Second Amendment analysis. The lower courts were instructed to reconsider the magazine ban under Bruen's historical framework. But instead of reversing course, the lower court upheld the ban again. Now the case is back before the Supreme Court, essentially saying, "We tried it your way. The lower courts are not following the framework. You need to step in." Here's where it becomes potentially historic. Both of these cases have been relisted. That means the justices did not deny them outright. They also did not grant them immediately. Instead, they moved them forward to be discussed again at a future conference, and not just once, multiple relists. When the court wants to deny a case, it usually does so quickly. The fact that these cases keep surviving conference after conference suggests serious internal discussion. The critical detail is the conference date, February 20th. These two cases will not be alone. Multiple other rifle and magazine ban challenges from different states and circuit courts are also scheduled for consideration at that same conference. We are looking at a cluster of cases raising the same constitutional question, arriving at the court's doorstep at the same time. Legal observers have tracked a pattern for years. When individual gun cases reach the Supreme Court, critics argue the case is the wrong vehicle. Maybe there are procedural complications. Maybe Maybe the factual record is imperfect. Maybe the ruling below was too narrow. That argument has worked before. The court has declined cases citing such concerns. But when multiple cases from multiple states present the same question, that excuse disappears. The court cannot say there is no clean vehicle. There are many vehicles parked right in front of them. They can choose the best one or consolidate several together. Either way, the procedural excuse becomes difficult to sustain. This is exactly the scenario certain justices signaled they were waiting for. In a prior term, when rifle ban cases were denied, at least one justice publicly indicated the court would address the issue within a term or two. That statement set expectations, and now that time has arrived. So what happens next? The first possibility is a grant of review. If the court grants one or more of these cases, we would see full briefing in the spring, oral arguments later, and potentially a major Second Amendment decision before the term ends. Such a ruling would determine whether commonly owned semi-automatic rifles and standard capacity magazines are protected by the Constitution. Given the court's current composition and the Bruen framework, many believe such a decision could have sweeping consequences for bans in states like California, New York, New Jersey, and Illinois. The second possibility is another relist. That would extend the timeline but keep the door open. It could signal that the justices are coordinating which case to take or whether to consolidate multiple cases. The third possibility is outright denial. If all of these cases are denied, it would leave lower court rulings in place and maintain bans affecting millions of Americans. However, denial seems less likely this time. The sheer volume of cases converging on a single conference makes it harder for the court to look away. Denying one case is easier to explain. Denying many cases raising the same issue from courts that openly contradict each other is far more difficult. There is also the broader context. The Bruen decision changed how Second Amendment cases must be analyzed. Courts must examine text, history, and tradition. Banning commonly owned firearms that have been legal and widely used for decades is difficult to justify under that framework. Some lower courts have relied on stretched historical analogies. Others have been accused of ignoring Bruen's instructions entirely. The Supreme Court is aware its precedent is being tested. Allowing that to continue could weaken the authority of its own rulings. So here we are, 1 week away from what could be the most consequential Supreme Court conference for gun rights in years. Multiple rifle and magazine ban challenges converging on February 20th. 2 lead cases surviving multiple relists, a clear circuit split, multiple procedural vehicles, and prior signals from justices that the issue must be addressed. The week after the conference, the court will release its order list. We will know whether these cases were granted, relisted again, or denied. That order list will answer the question hanging over the Second Amendment for years. Are the most commonly owned rifles and magazines in America constitutionally protected, or can they be banned? The answer will affect tens of millions of Americans, and we are just days away from finding out. So here's the bottom line. The Supreme Court has run out of road. For years, they've watched lower courts contradict each other on whether the Second Amendment protects commonly owned rifles and standard capacity magazines. They've heard the promises, seen the chaos grow, and now the moment of decision has arrived. February 20th brings multiple cases from across the country, each asking the same fundamental question. The justices can no longer hide behind procedural excuses. Grant these cases, and we finally get the clarity gun owners, lawmakers, and lower courts desperately need. Deny them, and millions remain in legal limbo, their constitutional rights uncertain. The order list is coming. The choice will be known, and the Second Amendment's future will take shape one way or another. We'll be here to cover it. Stay tuned. Make sure you subscribe to Weapons Law Advisor, and don't forget to like and comment on the video to help us reach our amazing milestone of 10,000 subscribers. Every single subscriber matters. Your support is what makes this journey possible.